Losing a parent is devastating. And right in the middle of that grief, the world doesn't pause. The phone starts ringing. The mail keeps arriving. The bills don't stop. And if nobody in your family knows what to do first, you can make mistakes in those first 30 days that cost you years of headaches and thousands of dollars. I've watched it happen. Families who thought they did everything right, good people with good intentions, made avoidable errors inside that first month because nobody ever walked them through it. So that's what this video is, a calm, practical walkthrough of the first 30 days. What to do, what not to do, and in what order. I'm Greg DuPont. I'm a certified financial planner, a probate attorney, and founder of DuPont Law Group. I'm on a mission to positively impact 1 million lives. This video is part of that mission. So let's get on it. Before anything else, I want to talk about the mistakes, because in the blur of those first 48 hours, well-meaning family members make decisions that can cause real damage. Don't pay anything yet, not a single bill, not a credit card balance, not a recurrent subscription. You don't know yet what the estate owes, what it has, or whether the probate is going to govern how money moves. Paying a debt now out of your own pocket or from your parents' accounts before authority is established can create legal problems down the road. Don't distribute anything. Not the jewelry, not the car, not the cash in the wallet, not the credenza, not the bank account. Even if you know your parent wanted your sister to have the ring, distribution before the estate process is complete can expose you personally to liability. And don't throw anything away. You know, I've seen families start cleaning out the house in the first week and accidentally discard documents that turn out to be insurance policies, stock certificates, or the original will. Nothing leaves that house until the documents have been located and reviewed. Nothing. That's the first rule. Stop, breathe, and don't move money or property before you know what you're dealing with. Right after you made it through the immediate arrangements, your next job is to secure the home and physical assets. If your parent lived alone, go change the locks or rekey them. You'll know who might have a key. Neighbors, former caregivers, old friends, it doesn't matter. You must control access now. Document the condition of the property. Walk through every room with your phone and take photos and video. If there's a vehicle, do the same thing. If there are valuables, firearms, jewelry, or collectibles, secure them in a safe place in the home. You're protecting the estate from the moment you walk in. Also verify that the homeowner's insurance policy is still active. An unoccupied property can trigger a lapse in coverage or coverage exclusion in some policies if it's vacant for more than 30 to 60 days. Call the insurer, tell them the situation, keep it active until the property is transferred or sold. This is the single most important thing you can do in the first week. You cannot make a single legitimate legal or financial decision until you know what documents exist and what they say. You're looking for the will, the trust, if there is one, a list of accounts and assets, beneficiary designation forms if they're available, insurance policies, deeds, vehicle titles, and the most recent tax returns. Look in the obvious places first: a home safe, a filing cabinet, a fireproof box, a safe deposit box at the bank. Check with their attorney or financial advisor, because one of them may be holding the original will. And here's something a lot of families miss. Locate the Social Security card and the birth certificate and death certificates too. You may need all those papers for what comes next. If you find the original will, do not copy it, do not fold it, do not mark it anyway. Treat it like evidence, because legally it is. Once a funeral home files the death certificate with the Vital Records Office, you can order multiple copies. And here's the thing most families get wrong. They order 2 or 3 copies and run out. Order many. Most families will need to order 10 to 12 certified copies at a minimum. If the estate has multiple bank accounts, insurance policies, retirement accounts, brokerage accounts, and real estate, each institution is going to want an original certified copy. They don't share. Each copy can run you anywhere from $20 to $30 depending on the county. Ordering extras up front is a fraction of the cost of having to reorder them weeks later with extra convenience fees. Remember what I said in step 1 about not paying anything? There's a narrow exception. Some bills cannot wait, and if left unpaid, they cause damage to the estate. Utilities on the home should stay on while the property is secured. The mortgage, if there is one, needs to stay current. The homeowner's insurance premium needs to be paid. These protect the asset. Everything else, the credit cards, medical bills, those can go on hold. Credit card companies, medical providers, and other unsecured creditors will have to wait for the probate process to determine priority of payment. Paying them now ahead of higher priority debts or before the estate's full liabilities are known can create legal exposure for you personally as executor or administrator. Notify the creditors in writing that the account holder is deceased and that the estate is being administered. That's it. You're not refusing to pay. You're establishing the proper legal sequence. Weeks 2 and 3 are when you start notifying the institutions. Bring a certified death certificate to every one of those conversations. Start with Social Security. The funeral home often reports the death directly, but verify it yourself. Contact the banks and brokerage accounts, not to withdraw or transfer, but to identify what's there, who the listed beneficiaries are, and whether the accounts are payable on death or held in trust. Accounts with beneficiary designations or POD designations may pass outside of probate entirely, and that's good news, but you need to know which ones are. Contact the life insurance companies. A death benefit claim requires a certified death certificate and a completed claim form. Most insurers process this within 30 to 60 days of a complete claim. Contact the pension administrator or former employer if your parent had a pension or deferred compensation plan. If your parent had Medicare or Medicaid, notify those agencies too. Medicaid in particular has recovery provisions that the estate may need to address. Now comes the most important question that will shape everything else. Does this estate need to go through probate? And if so, how fast does it need to start? Probate is the court-supervised process of validating the will, appointing an executor, paying debts, and distributing the estate. Ohio does not have a strict legal deadline or time limit to initially open a probate case after someone dies. However, once estate administration is officially opened, the appointed executor or administrator must follow strict statutory deadlines for specific actions during the process. And the longer you wait to file, the longer assets will remain frozen. Not all estates go through probate. Assets held in a revocable living trust, accounts with valid beneficiary designations, jointly held property with rights to survivorship, and payable on death accounts all pass outside of probate entirely. That's exactly why a well-designed estate plan is so valuable. It's about control. A family with properly funded trust and updated beneficiary designations can often skip probate entirely, which means no court delays, no public record, and no attorney fees eating into what your parent left behind. If you're not sure whether your parent's estate requires probate, that is exactly the moment to talk to an attorney that specializes in this kind of work. So those are the 7 steps for the first 30 days. Hold off on payments and distributions, secure the property, locate every document, order around 10 death certificates, protect the estate assets strategically, contact Social Security, the banks, and the insurers, and then determine whether you need to file probate. If your family is navigating this right now, or if you want to make sure your own estate doesn't put your kids through an avoidable ordeal, we'd welcome the opportunity to sit down with you and help. Go to the link in the description below to download our probate checklist, or reach out to us directly at 614-408-0529. Take care and be well.